Republic Act Number 11,642, January 06, 2022, an act strengthening alternative childcare by providing for an administrative process of domestic adoption, reorganizing for the purpose the Intercountry Adoption Board, ICAB, into the National Authority for Childcare, NACC. Amending for the purpose Republic Act Number 8043, Republic Act Number 11222, and Republic Act Number 10165, repealing Republic Act Number 8552 and Republic Act Number 9523, and appropriating funds therefor. Republic Act Number 11,642, Article 1, Section 4D, provides that adoption refers to the socio-legal process of providing a permanent family to a child whose parents had voluntarily or involuntarily given up their parental rights, permanently transferring all rights and responsibilities, along with filiation, making the child a legitimate child of the adoptive parents. Provided that adult adoption shall be covered by the benefits of this act. In the interest of clarity, adoption shall cease to be part of alternative child care and becomes parental care as soon as the process is completed. Republic Act Number 11,642, also known as the Domestic Administrative Adoption and Alternative Child Care Act, is the modern law on adoption in the Philippines. It replaced and updated the adoption rules originally found in the Family Code of the Philippines. Its main purpose is to make adoption faster, simpler, and less expensive. Below is a simplified explanation of 11,642 relates to and amends the Family Code. 1. Shift from judicial to administrative adoption. The biggest change introduced by RA number 11,642 is who handles adoption cases. Family Code. Adoption was a court process. Prospective adoptive parents had to file petitions in court and wait for a judge's decision. RA number 11,642. Adoption is now an administrative process handled by the National Authority for Child Care, NACC. This removes the need for long court trials and makes domestic adoption more efficient. Point 2. Qualifications and age requirements. Amending Article 183 RA number 11,642 clarifies the qualifications of adoptive parents. Age of adopter. Family Code. Adopter must be of age. RA number 11,642. Adopter must be at least 25 years old. Age gap. Both laws require the adopter to be at least 16 years older than the adoptee, unless the adopter is the biological parent or the spouse of the biological parent. Financial capacity. Both laws require the adopter to be capable of supporting and caring for the child. Point 3. Mandatory joint adoption by spouses. Amending Article 185. The rule on joint adoption remains, but with clearer exceptions. General rule. Husband and wife must jointly adopt. Exceptions under RA number 11,642. One spouse may adopt alone if adopting the legitimate child of the other spouse, adopting their own illegitimate child with the other spouse's consent, or the spouses are legally separated. Point 4. Who may be adopted. Amending Article 187, the law expands who may be adopted. Adult adoption, Family Code. Adult adoption allowed only if the adoptee was treated as a child during minority. RA number 11,642 allows adoption of a Filipino adult who was consistently treated as a child for at least 3 years. Legal availability. The law introduces the certificate declaring a child legally available for adoption, CDCLAA, as proof that a child may be legally adopted. 5. Rescission of adoption. Amending Articles 191 and 192 RA number 11,642 strongly protects the child's stability. Family Code. Both the adopter and adoptee could seek rescission of adoption. RA number 11,642, only the adoptee may seek rescission. The adopter cannot rescind the adoption. The adopter's remedy against an erring adoptee is disinheritance, not rescission. Point 6. Repealing chain and legal evolution. RA number 11,642 is part of the evolution of adoption laws. Family Code, 1987, Original Adoption Provisions, RA number .8552, 1998, replaced many Family Code rules. RA number 11642, 2022, repealed RA number 8552 and RA number 9523, and modified all inconsistent laws, including relevant provisions of the Family Code. In summary, Republic Act number 11,642 modernizes Philippine adoption law by shifting adoption from courts to an administrative process, making adoption faster and more accessible, strengthening child protection, and ensuring that adoption truly serves the best interest of the child. In relation to Article 183, the law specifies the qualifications of adopters by requiring them to be at least 25 years old, with full civil capacity and the ability to support the child. It also retains the 16-year age gap between adopter and adoptee, including the same exceptions when the adopter is the biological parent or the spouse of the biological parent. While the Family Code generally focused on the adoption of minors, RA number 11,642 further allows the adoption of a Filipino adult who has been consistently treated as the adopter's own child for at least 3 years. In relation to Article 184, RA number 11,642 preserves the disqualifications and restrictions on adopters, but adapts them to an administrative system. The law continues to disqualify persons convicted of crimes involving moral turpitude and allows guardians to adopt their wards only after the termination of guardianship and settlement of accounts. It also expands the rules on foreign adopters, allowing foreign nationals to adopt if they have been habitual residents of the Philippines for at least 5 years, while retaining the Family Code's exceptions. Most importantly, RA number 11,642 shifts the determination of these qualifications from the courts to the National Authority for Child Care, NACC, replacing the judicial process under the Family Code with a faster administrative proceeding. Article 185 of the Family Code provides that husband and wife must adopt jointly, so that both spouses share parental authority over the adopted child. This rule is retained under Republic Act number 11,642, as it ensures that the child becomes part of a complete and unified family. Republic Act number 11,642 also clarifies and expands the exceptions to joint adoption. A spouse may adopt alone if they are adopting the legitimate child of the other spouse or their own illegitimate child, provided that the other spouse gives written consent. The law further adds a new exception by allowing legally separated spouses to adopt individually. While the rule under the Family Code was applied through the courts, RA number 11,642 now places these matters under the National Authority for Child Care, NACC, through an administrative process, making adoption faster and more efficient. Article 186 provides that once adoption is completed, the adopted child becomes the legitimate child of the adopter. All legal ties with the biological parents are severed, except when the biological parent is the spouse of the adopter. Under RA number 11,642, this effect is fully retained. Adoption permanently transfers parental authority, rights, and obligations to the adoptive parents, and adoption ceases to be considered alternative child care once finalized. Article 187 allows the adoption of minors and, in limited cases, persons of legal age who were treated as children during minority. RA number 11,642 expands and clarifies this by allowing the adoption of a Filipino adult who has been consistently treated as the adopter's own child for at least 3 years. It also introduces the requirement that a child must be declared legally available for adoption through a certificate declaring a child legally available for adoption, CDCLAA. Article 188 requires the written consent of persons whose rights may be affected by the adoption, such as the biological parents, the spouse of the adopter, and the adoptee if of sufficient age, RA number 11,642 retains this requirement and further strengthens it by expressly requiring the written consent of legitimate and adopted children aged 10 years or older of the adopter, ensuring that the adoption respects family relationships. Article 189 mandates that adoption proceedings and records are confidential to protect the privacy of the parties involved. This principle is preserved under RA number 11,642, which continues to ensure the confidentiality of adoption records while allowing access only to authorized persons or upon order of the proper authority. Article 190 allows the rescission of adoption, subject to grounds and procedures provided by law. RA number 11,642 significantly modifies this rule by providing that only the adoptee may seek rescission of adoption. The adopter can no longer rescind the adoption, emphasizing the law's policy of protecting the child's stability and best interest. Article 191 of the Family Code lists the grounds for rescission of adoption, such as repeated maltreatment by the adopter, attempt on the life of the adoptee, sexual assault, or abandonment and failure to comply with parental obligations. Under Republic Act No. 11,642, this provision is substantially modified. The law emphasizes that adoption serves the best interest of the child, and therefore only the adoptee is allowed to seek rescission. The adopter is no longer permitted to rescind the adoption. Article 192 provides the legal effects once adoption is rescinded, including the restoration of parental authority to the biological parents and the loss of rights of the adoptive parents. RA number 11,642 retains the general effects of rescission but limits their application because rescission may now be initiated only by the adoptee. This restriction strengthens the child's right to stability and protection. Article 193 governs the successional rights of adopted children, placing them on the same level as legitimate children with respect to inheritance. Number 11,642 maintains this principle. An adopted child continues to enjoy the same successional rights as a legitimate child, even under the administrative adoption system, unless adoption is lawfully rescinded at the instance of the adoptee. Following the enactment of RA 11,642, or the Domestic Administrative Adoption and Alternative Child Care Act, the Supreme Court has issued guidelines on the implications of the law on the rule on adoption. In an in-bank resolution, the court adopted the recommendations of the Committee on Family Courts and Juvenile Concerns, led by then Senior Associate Justice Estela M. Perlas-Bernabe, as follows. Upon effectivity of RA 11,642, courts may no longer receive or accept petitions for domestic adoption. Jurisdiction over domestic adoption cases shall now be with the newly created National Authority for Child Care, NACC, a quasi-judicial agency attached to the Department of Social Welfare and Development. Adoptions proceedings are now administrative. Petitioners have the option to immediately withdraw judicial petitions for domestic adoption pending in court, regardless of the stage of the proceedings. Otherwise, the courts shall continue to hear and decide such petitions. The courts shall give petitioners time to manifest their intent to withdraw. If petitioners fail to notify the court within the set period, they are considered to have waived the option to withdraw their petitions. Petitioners and their respective counsels who avail of the benefits of RA 11,642 without first withdrawing their pending petitions before the courts shall be sanctioned under the rules of court. Domestic adoption provisions in the Rule on Adoption are now rendered ineffective except for pending domestic cases before the courts not withdrawn by petitioners. Rescission of adoption under Section 47 of RA 11,642 covers judicial adoptions. Intercountry adoption petitions pending before the courts pursuant to Part B of the Rule on Adoption shall be dismissed. All courts are required to submit to the Office of the Court Administrator a list and status report of all pending adoption cases, including archived cases. RA 11,642 took effect on the 28th of January 2022, with the goal of making domestic adoption proceedings simpler and less costly. The law also seeks to streamline alternative child care services.